We are now transitioning into a presentation by Darren, Pruslow, and Margaret Kuzma about character of discharge determinations, which are still on the VA side, and also military discharge upgrade applications, which actually shift over to the Department of Defense side of things. And just to let you know, all the students in the rooms, and your clinicians are very likely to tell you this anyway, but this whole day you've been learning from leading experts in this field. It's really quite incredible to watch it all unfold. And this next presentation is no different. And so hopefully, Darren, are you able to share your screen? And I can transition to you.
Sure. Good afternoon, everyone.
And you might need to bump up your mic volume just a skosh. I don't know if people say skosh anymore, but I just did. So
is that any better?
It is. Thank you.
Yeah, usually people don't tell me to be louder, so that's nice to hear. Good afternoon. My name is Darren Pruslow, and I'm here with my colleague, Margaret Kuzma. We work with the Connecticut Veterans Legal Center, and I also run the Veterans Clinic at Quinnipiac University School of Law. So today, we're going to talk about upgrading military discharges, both from the VA side, as Hillary mentioned, and also from the Department of Defense side. To get us started, though, we're going to kind of hear it from a veteran who has dealt with this issue. And she's going to give a little better talk about this than I can. Hopefully this sounds okay. Is this coming through okay?
Darren, you might need to share your sound as well.
Is that not coming through?
It's not. I think there's a little box at the bottom when you do the share screen.
Okay, one sec. When I share this, or sorry about this. Double checking that it's sharing the volume.
How about stop share, and then when you click share screen again, there should be a box at the bottom of that that says share my computer sound.
Got it.
Do you see that?
Thank
Great.
you. Okay, perfect. So I'm going to restart it.
My name is Morgan Gray. I enlisted in the United States Marine Corps in 2006 and was discharged in 2010 with another than honorable discharge. I earned, a good conduct medal, meritorious mast, and meritorious promotion for getting first in my class in MOS school.
I think a lot of folks assume that they must have done something terrible in order to get kicked out with an other than honorable discharge. But what I see is quite the opposite.
After the first couple of weeks, I found myself wanting to take more of them, even though I didn't necessarily feel like I needed them anymore. I went to one of my corporals and I asked for help. Told him, I said, I think I have a problem with pain medicine. I think I need some help. His response was, stop being a vagina and go back to work. And then a week later, I popped on a drug test. It just kicked me out with a drug habit. So I started with the VA in South Florida. They would ask me, what kind of discharge do you have? And as soon as I said other than honorable, they said, I'm sorry, you're not eligible for VA benefits.
those who experience trauma end up suffering while they're still on active duty. They get kicked out with a less than honorable discharge, and then the door is shut at them at the VA. And so it is exactly this population of veterans who we want to be providing health care and services and monetary benefits for. We see in studies with much higher rates of homelessness, of incarceration, and suicidal ideation. It's a population that tends to be much more impoverished and much more vulnerable than those with an honorable discharge.
I ended up living on the streets in South Florida for almost a year and a half, homeless, addicted to addicted to painkillers, until I got pregnant, and then I got arrested. Going from being a United States Marine and being so proud of who I was to being this person that my family couldn't stand to even speak to, let alone see, you know, it's pretty messed up. I quit for a long time because I got told no and got so many doors shut in my face. I gave up until I found the legal system in West Haven.
In order for those vets who need veterans benefits to get served by the VA, the VA needs to go back and draft regulation that comports with what Congress intended at the time, so that those with minor misconduct are no longer having the door shut on them at the VA.
What happened to me then has made me the person that I am today, that wants to help in any way that I can. So don't quit. There's always a way to get what you deserve and to get the help that you need.
Okay, so I think that's a pretty compelling story that unfortunately we hear way too often about veterans who are struggling to get into either VA healthcare, to connect access to benefits, a variety of reasons. So what we're going to go over today is a couple of things. We're going to go over, one, how the discharge process works on the DOD side, why that discharge process matters. Then Margaret's going to talk a bit about how to change that through the DOD, through what we call a discharge upgrade or a DU. Then I'm going to talk a little bit about how you would do that on the VA side through what we call a character of discharge determination or a COD. And then we have a case study that we're going to discuss at the end to see maybe if you were facing one of these in the clinical experience, how you would deal with it and what to be thinking about as you go through the process. So, military regulations, each branch has their own set of rules for how they go through the discharge process. And here's a helpful site for each of those different branches. From an understanding of agency law, right, the Department of Defense gets to determine how someone leaves the DOD. The VA picks up the other side and figures out whether or not they are a veteran and how to deal with them on that end. So it's this DD 214 document that sets up what someone's services through the VA. You are going to see these forms a lot. They should be in the military personnel file. And often many veterans will actually carry them with them because they're asked for them so often. So when you look at this form for what we're doing, there are a couple of pieces that are pretty important. There is the character of service, and then there is the narrative reason for separation. Now, depending on when they served, this form has changed over time. So if you look at someone who served during Vietnam, the form will be a little bit different in different pieces, and it's changed over time, but the same general information is there. This is a one-page, usually snapshot, that summarizes all the veteran service. And we'll bring back one later to show you to kind of see how you would find some of this information. But I'm going to go over a little bit about what the character service piece is, and then the narrative piece as it impacts the work that we're going to do. Oh, okay. So these are the different types of discharge characterization, right? You've probably heard of honorable. We've heard the mention of OTH, or other than honorable, general, GUS sometimes, or GUH, uncharacterized, bad conduct, and dishonorable. They break down into two groups. So if you think about it from a criminal law standpoint, for those of you with that background, administrative separations are non-judicial in the sense where there's not a judge, they're not going through the court-martial process, and then oftentimes it feels more like a plea deal. So keeping that in mind when thinking about that process. Punitive separations, although they can be pled out, usually require a court-martial process, and therefore a lot more due process attaches. For these administrative discharges, right, which are the ones which we'll be dealing with more in the discharge, upgrade, and COD process, the commander on base has a lot to say on what happens. And you've heard about this in some major cases where, in one way or the other, the top person involved will overturn the decision or do something different if they so choose. You'll hear things about counseling and rehabilitative efforts. Those are not clinical, right? When someone is getting counseling, it means they're being written up, right, by their supervising officer, right? There'll be reports from the commander. There'll be some notices of service of rights that are in the file. And in some cases, there'll be a hearing. And in not usually administrative cases, it actually can be a transcript. As in with many cases, which we see in other courts, as people are going through this process, they're very quick to waive their rights. And you'll often hear and see, oh, they waive this, they waive that. Because sometimes by the point when they get to the discharge process, they just want to get out of there. And there's other reasons behind that as well. There's often a narrative given for the separation. So it sort of explains why that characterization exists. Misconduct, pattern of misconduct, and these will kind of lay over to different things on the VA side, which we'll talk about later. Some of these obviously are no longer used anymore, and some of them are, right? But these will be on the DD-214 form. So when a veteran presents their form to either an employer or anyone for services, they get this summary and they could see that, oh yeah, they had alcohol and drug abuse or failure or serious offenses, and that will follow them for the rest of their lives as long as someone looks at their service. So a little bit about why this progress matters. When it comes to the VA doesn't issue the DD-214. They are bound by whatever that form says. What the VA regs do is it allows them to interpret that form for VA purposes. So on the DOD side, their job is to get a veteran out, and they issue the DD-214. The VA's job is to actually treat veterans and make sure they get the services they need based on their service. Honorable and general are pretty straightforward. They are honorable for VA purposes, and we'll talk about that definition later, right? But once you get to the other characterizations, the VA has some discretion on whether or not that translates over to being eligible VA benefits or not. And oftentimes this gets complicated and confused, and we'll go into that as well, right? Why do these characterizations matter? This characterization determines whether or not you get access to health care, compensation-free disability, right? The non-service-connected pension, whether you get the GI Bill and the home loan, right? And some of these actually require you to be on the honorable level, right? If you have a general, even though you're honorable for VA purposes, you don't get your GI Bill benefits. You don't access the home loan, right? You go to employers that were hiring based on veterans benefits or veteran preference will ask you for DD-214. And as you can imagine, seeing these forms can bring up stigma and shame depending on what they say. And for that, I have someone else to speak on that. Yep.
Hello, my name is David Villa. And if you can bear with this intensely patriotic backdrop and me fading in and out of it, I'd like to talk to you a little bit about military and veteran culture and discharge upgrade. I'm a 2020 summer legal intern with the Connecticut Veterans Legal Center. And in the life before law school, I served with the 82nd Airborne Division, U.S. Army Civil Affairs and Psychological Operations Command, and was a military contractor for about 8 years. During that time, I deployed multiple times to both Afghanistan and Iraq. So the first thing I want to tell you about veteran military culture is that veterans and military folk are not some strange, different breed of human. They're just like each of you. I think some people think that when they hear about the military, they tell themselves that they don't like to get up early in the morning, or they don't want to exercise too much, or they don't want to get yelled at. And they say that's not for me. But what I'd like to tell you is that the military is very good at turning civilians into service members, and that there is a version of each of you somewhere in our military. What sets veterans apart from civilians, I think, is obviously that military experience and the kind of experiences that people do have in the military. Obviously, overseas in wartime fighting, those differences can be very extreme. But even in mundane garrison military settings, there is a difference in culture, primarily having to do with community-based cultures. In the military, you're never alone. You're always part of a team. Everything is a team effort. Your value in the military is determined at any given point by what you can deliver to your team. And I think that gives veterans a great sense of belonging and purpose and meaning. So when a veteran leaves the military and comes back to the civilian world, a lot of veteran difficulty is readjusting to a world that is individualistic, where you don't have a teammate with you all the time. You're alone. Another thing that can complicate the transition back to the civilian world is not only when you are no longer part of the military team, but when your military record is marked by less than honorable service. That might tell a veteran that they weren't really part of the team, or that time didn't really count, or that they weren't honorable in their time. And that can have severe damaging consequences for their sense of identity as a veteran. Of course, those less than honorable discharge upgrades can also be the bar to necessary health resources. But at the very bottom of that, it's a bar to a reputable identity as a veteran. And so part of the mission for discharge upgrade is to help repair that identity, help a veteran count their service time so that they can maintain that veteran identity that is so important to them. Thanks for listening.
So let's talk a little bit about how this is going to come up for veterans when dealing with the VA, or generally speaking, right? So when you go to the VA and present for the first time, they are going to ask you about your eligibility. There are frontline staff in the VA hospital where their sole job is to determine whether or not a veteran has the right to access VA healthcare, right? And there are many occasions where veterans have been turned away where they're not given the appropriate review. So that's on the VA healthcare side. What's supposed to happen is the VA healthcare side, if they are unsure, should turn it over to the benefits side of the house for them to analyze it. And they often don't even do that process properly. On the benefit side, when you file for an application, they also look at your eligibility, and if it's in question, they'll trigger what's called a character of discharge determination, or a COD. And then there's also, within the community, many of the veterans organizations that get VA funding, like Supportive Service of Veterans and Families, they require the DD-214. Although there's different eligibility for different programs in the VA, it still comes up. There are two paths to fix this, right? One is through the Department of Defense, which Margaret's going to start to talk about in a few minutes, which is called the discharge upgrade. And then I'll come back and talk about the VA. And we'll go from there. Each path has their pros and cons and different benefits and things to keep in mind. But but we'll discuss that where it goes. And I think I'm going to switch over to Margaret.
Okay, can everybody hear me? Yes, awesome. Pretty soon you can see my slides, and then I will have passed the test. All right, great. Okay, so thank you, Darren. You all have now heard Morgan's incredible story. You heard from David, you heard from Darren. You know this is incredibly important work, and I'm sure you're all really excited to start. So I'm going to give you a view from 30,000 feet, very quick overview of how to do these cases. And I thought the best way to start it is to go through a hypothetical and familiarize yourself with these facts. We're going to come back to it after I teach you the different elements of a DU, and then we'll try to apply them throughout the presentation. So Sam, post 9/11 Marine veteran, tour of service was 2003 to 2006. He almost completed his 4-year term of enlistment. First 2 years, totally fine, no misconduct. And then at the beginning of his 3rd year, he was sexually assaulted. Shortly after the assault, not surprisingly, he started to have some mental health effects, and he showed up late for duty. He received an other than honorable, or I mean, scratch that. He had an UA, a unauthorized absence. Couple months later, he went UA again, and then he popped for a drug test. Chain of command looked at the misconduct and they separated him. Just like Darren talked about, they do have a lot of discretion, and they decided in his case that he should get a narrative reason of pattern of misconduct. The separation authority was the MCO paragraph 6210.3, which Darren talked about a little bit, but it probably still seems like gobbledygook to you. We're going to go over that in a bit. And he got an OTH that Darren also told you about. So he wants that upgraded. He wants it for a variety of reasons, for employment, for access to healthcare. He has PTSD, so he really needs that healthcare. And he wants to use his GI Bill benefits. And last but absolutely not least, he wants to get rid of that shameful label on his service, just like David talked about how it can be almost like being excommunicated from this band of brothers that you've been with, or band of sisters. So now you know what he wants. You have this veteran that has walked into your clinic. Where do you go? So you've heard a lot about the VA. You're going to exit the VA for a discharge upgrade and walk over to the Department of Defense, the DOD, where every branch of service has their own 2 levels of review boards. Marines comes under the Navy. So you have discharge review boards and boards for correction of military records. For the Navy, it's Board for Correction of Naval Records, because they're special. It's BCNR, but don't let that throw you. They're all the same, or relatively so. So DRBs, very quick overview of them. 15 years from the date of discharge. So if you have somebody who walks in and they are within 15 years of being discharged, you are almost always going to go to the DRB. There are a few limited exceptions where the DRB will not be able to give you the remedy that the client wants, in which case you have to go to the BCMR. But usually if you're within that 15 years, you have to go to the DRB first. If you try to go to the BCMR and the DRB can give you the remedy you want, they're going to kick it back to you. And they're probably going to take a while to kick it back to you, which is just going to waste a lot of time. So make sure you go to the right board. Okay, so what can DRBs do? DRBs can upgrade that character of discharge, so they can take you from other than honorable to honorable. They could upgrade it from other than honorable to general. All of those will, as Darren said, the VA is bound by what that DD 214 says, so all of those will open up lots of doors. They can also change the narrative reason for separation, so they can change it from something that would be stigmatizing to something innocuous like secretarial authority. They cannot change it to medical retirement because that's technically medically retiring a veteran, and that's a whole nother process that's complicated, fun, but way beyond the scope of how much time I've been allotted. You have to go to the BCMRs for that one. Okay, other things that they cannot do, they cannot reinstate people into the service. And excitingly, they cannot issue a less favorable discharge than what the veteran got. So if you have a veteran who comes in with a general, and he wants to say use the GI Bill, but he can't because he has a general under honorable, then, you know, and you take it to the DRB can't say you were super lucky to get a general, we're actually going to give you an other than honorable. That can't happen. You can't do harm. You're only going to help the veteran. So very good news. All right. I just got a message that I'm cracking. Do you guys hear me okay? Okay. All right. So with a DRB, there are two types of review. You can either do a records review or a personal appearance hearing. If you try for the records review first, then, and you don't get everything you want, then you can go and actually have another bite at the apple at the Discharge Review Board and have a hearing. Only within those 15 years though. So that's if you're outside the 15 years, then you're into the DMR, no exceptions on that one. There are reasons why you might not want to do the two-step process. For example, if you have a veteran who comes to you at year 14, and you know a personal hearing is going to be better in that case, then you might want to go straight to the personal hearing so that you don't lose that opportunity because the 15 years lapses. Okay, so now we're going to shift gears to the BCMRs. So I've been talking about 15 years, 15 years, 15 years. That's the set in stone DRB statute of limitations. Board for Correction of Military Records is much more flexible. So they have a 3-year statute of limitations, but there are all kinds of exceptions that you can use to get around. So it's 3 years from the date of discharge, or 3 years from the negative DRB decision, or 3 years from when the veteran actually discovered or had knowledge that there was an error or injustice. Or the veteran can get the 3-year statute of limitations waived if it's in the interests of justice, which the boards very liberally, in most cases, waive if you make the argument. And you can get it completely waived if the case happens to come under some of the Department of Defense memos that have recently come out, and we're going to get to those in a minute. Okay, so BCMRs can do everything the DRBs can do and a lot more. For instance, when I said DRBs cannot medically retire a veteran, BCMRs can. They can actually put a veteran back on active duty service, which is super fun, and I would love to tell stories about that, but I don't have time. They can, as I said, review denials from the DRB. You name it, they can mostly do it. One thing they cannot do is, although they can review court-martial decisions and upgrade from, let's say somebody got a bad conduct discharge, they can upgrade it even all the way up to an honorable, but they can't get rid of the underlying conviction. That's going to stay. So as far as what review you're going to get from the BCMR, you can technically get a hearing, but it's not going to happen. I always ask for one, and I have never gotten one, and I have never talked to anybody who's gotten one. I always say whenever I give a presentation, if anyone in the audience ever gets one, I want them to immediately call me because I would love to hear about it. But they're incredibly rare. So be prepared to just have that documentary review. All right, so knowing all of that, let's revisit our hypothetical, review the facts a little bit, and then think about where he should file and what type of review he should ask for. Okay. Also, let me know if there's still feedback. I don't know what to do about that. So hopefully you all have in your minds thought through this and decided that he should go to the DRB. And although usually you would do a records review first, you might want to consider doing the hearing first because he is coming very close to that 15-year statute of limitations. So, all right, now you know where you're going. How do you do that? I'm going to go through a couple DU best practices. I can't go through them all, but I'm going to give you as much knowledge as I can in this tiny amount of time. Okay, so what do you have to have in a DU application? All that you actually have to have is a DD 293 or a 149. And if you can, I don't know, have magical superpowers and see these tiny little documents that I put on there, that's what those are. They're front and back. They give you about this much room to make your legal argument. A lot of veterans only fill those out and put in their DD 214 and they lose because it's incredibly hard to make a legal argument in this amount of space. And if you can do it, then you need to come and teach me because I certainly cannot do it. I put a ton of stuff in there. So you can see the list of things that at CDLC we usually also include in our applications. And if you would like to see the 149 or the 293, you can Google them and you can find them online. But don't do that now because you're paying attention to me and you would never do that. Okay, so if you're going to take one of these cases, what is the legal standard? All right, so this is where I think this work gets really fun because when I went to law school, I was, a bright-eyed young person and really wanted to fight injustice and then, got into first-year torts and wondered what I was doing. But here you actually have a legal standard that is injustice. It's amazing. So, in one of the student panels, you heard people talking about how clinics are great because they get to be creative. This is the most creative type of law I can think of because you get to tell the veteran story. You get to throw in all of these pieces of arguments to say that the discharge was inequitable or unjust or improper or it was in error. So there are some standards that you need to tether your arguments to, but in general, you've got a lot of wiggle room. Okay, so as I said, there are some standards that you need to tether your arguments to, but you've got a lot of room. These are standards that I've drawn out of the CFR. Technically, they only apply to the DRB. So it's equity and impropriety at the DRBs, but they're very much sister standards. So equity is very similar to injustice, and I use them for both types. I just, footnote that this applies to the DRB, but I'm using it for the BCMR because yada, yada, yada. And it's never been a problem for me. So I'm not going to read all of these to you because I don't have time and because you have them in your packets, but I do want to highlight number one, which I think of as future policy change. And I want to highlight this one because I use it all the time and I think it's such an amazing very favorable standard for us. It's, so you have a veteran, he was discharged under a policy that no longer exists, or a new one provides much more robust protections for that veteran. It's not an impropriety, because when the veteran was serving, what happened to the veteran was fine. It was within the commander's discretion, and there was no error there. But because now you have a policy that's more veteran friendly, more service member friendly, then that's actually an inequity, which is, I think, really cool. It's not really retroactive, but it has a very similar effect. And we use it all the time, especially with cases that deal with mental health, because there have been so many developments as medical knowledge changes and as the military acknowledges that this does happen, unfortunately, too frequently. You can make a lot of arguments based on changes in policy. Okay, so improprieties or errors. So the key thing to think of here is that it's not just an error or an impropriety, but it's something that's prejudicial. So when you're going through the military record, when you're talking to the veteran and trying to pull out if anything happened that was wrong, that was an error, you really need to find something that kind of passes a somewhat of a but-for test. So, but for that error, he wouldn't have gotten this other than honorable. Okay, so we are going to talk a little bit very quickly about some DOD memoranda, so Department of Defense memos. And these are all named in DU world after the secretaries that put them out. But, for example, Chuck Hagel actually wrote a lot of memos. We just call this one specific memo the Hagel Memo because that's all we care about. So when you're writing your brief, you're going to want to actually cite to the real memo, but they'll probably know what you're talking about. So let's start with the Hagel Memo. This was a just sea change event when this came down. Prior to September 4th, 2014, if you had a veteran go to one of the boards for correction and say, I served in Vietnam, I now have diagnosed PTSD, but at the time, nobody even knew what PTSD was, and I had this misconduct. I went AWOL because I was suffering, and I should get an upgrade because, it's unjust. Prior to the Hagel Memo, the boards generally said, too sad, too bad, so sad, and they got denied. I think the approval rate was something like 5%. After the Hagel Memo, that went up in some boards to around 60% if you had a mental health condition like PTSD. So they changed the standard, they changed it to liberal consideration, and I put that in quotes, one, because I talk with my hands all the time, as you probably noticed, but also because it's not actually defined here. So that gives you a lot of wiggle room, which I find fun. It's also kind of frustrating because you're not really sure what the board is going to do with that. But just know that with a Hagel Memo, things got a lot better for veterans, and it kind of opened the door to mental health claims being far more likely to be granted. So then along comes the Carson Memo, and if Hagel opened the door, Carson opens it a little bit wider. So as I said, the time limits at the beginning, those statute of limitations, that 3 years is waived. Not for the DRB, 15 years, still set in stone. You can also get cases, if you brought them before Hagel, you can get a de novo review of those. And again, opening the door slightly wider, in addition to PTSD, TBI, traumatic brain injury, is now one of the conditions that can get you that liberal consideration. And then along comes Kurta, and I should mention that all of these memos are in your packet, and if you are even considering doing a discharge upgrade, read them and read them again and again, because there's all kinds of good stuff in there for you. I just pulled out a tiny bit of the golden nuggets from Kurta here. If, you know, Carson got you here on the open door, then this really opens it up. In addition to PTSD and TBI, you have mental health conditions in general. They also specifically mention sexual assault and sexual harassment. So there are a lot more cases where you can bring it under the auspices of this liberal consideration, much more veteran-friendly standard. Okay. The other thing that Kurta does is it gives us these questions. And as I said, the liberal consideration standard is great in that it's flexible, but it's kind of frustrating in that you don't know what the board is going to do with it. This gives you a much clearer idea. And the way I use these questions is when I'm writing a Kurta-based memo, or brief, I actually specifically answer the questions for the boards, because these boards or these memos are written for the boards. So the boards are supposed to ask these questions. So they're very helpful to us as advocates, because now we know what the boards are going to do when they get this case, or at least what they are supposed to do when they get this case. And then I've given you 3 memos that are mental health based. Then comes the Wilkie Memo, and it is for all cases. So, you know, the non-mental health based cases were kind of lonely. They didn't really have good standards for them. They still were being denied at a very high rate. Wilkie comes along and really helps to further define and I think expand that equitable and injustice framework. It also talks a lot about clemency, which we're not going to get into, but clemency is the standard for when you're dealing with something that went through a court martial. So very helpful for those as well. Essentially, when you think of the Wilkie Memo, and again, like, read it a million times if you're going to do a DU memo or a DU case, because it's super helpful, but it's really all about fundamental fairness and second chances and making sure that, you know, if a veteran was punished, it's maybe they should have been rehabilitated, or they should have been given a second chance, or at least now, you know, they've lived with it long enough that we can upgrade them. So incredibly helpful. So let's go back to Sam. Again, look through the facts and then think about what DOD memos apply. Okay, is everybody ready? I guess I can't tell, so I'm just going to go forward. Which memos apply? I think all of them do. So he has PTSD, so you have all of those mental health related memos. And then you have Wilkie, and we don't know what his pre-service or his post-service was, which Wilkie looks at, but usually you can draw something out of there that's really positive. But then you can also argue for the second chance. What happened to him was awful, and he had at least 2 good years of service. So, you know, you can make those arguments about second chances. If, you know, anybody deserves one, I think it's somebody who has had to go through what he did. Okay, so now you know something about the legal standards, you know about some of these helpful memos. How would you go about building a case? So I could talk for 6 hours on this. I know you guys have already heard about 6 hours of content. So I know you're probably saying, please, we didn't even have lunch, which was not my fault, by the way. So I'm just going to focus in on a couple narrow things that I think would be helpful. And as a small caveat, I have these numbered as step 1, step 2, step 3. They don't necessarily go sequentially. Sometimes it depends on how long it takes the records to get to you. I don't know if you had a panel on record collection. If you didn't, it's a blast and you'll love it. It's actually really awful. But once you get those records, then you can really kind of fly with going through the case. So starting with the initial interview, the first thing that we do at CBLC when possible, and it's usually possible for the veteran to get the DD-214, is we look at that DD-214 because it's only one sheet of paper, but as Darren showed you, there's a lot of stuff on there. And it's a document we're trying to change. So we review that, we get some idea when they served, where they served, and what type of discharge we're dealing with. Then we interview the veteran, and I have a couple techniques here on how I go about an interview. And the main thing to remember, I think, with interviewing any client is what you heard in the last panel. You really have to let the veteran lead a little bit. So I try to draw out information, ideally from the pre-service life, the life in service, and the post-service life at some point in my representation, because that's going to go into my brief and that's going to go into the personal statement. But you don't always get that in the first interview. It really depends on where the veteran is. So I put that there because that's all great information to get, but you may not get it in the first interview. Okay, so now step 2, you start collecting things. Ideally in that first interview, you've had them fill out all of these different forms to start the records review process. And then while you're waiting on those, you can start collecting things like supporting letters. Supporting letters can be from people the veteran served with, they can be from family members, they can be from JAG. And I love putting JAG on here because sometimes, people are nervous about reaching out to service members, particularly ones that maybe had a part to play in the discharge, but we've had tremendous luck with JAGs remembering cases and being willing to write affidavits about them. Same with former chains of command. We've had commanders who actually were responsible for getting, the OTH as opposed to, say, a general. And, a lot of times the commanders are 27 when they're making these decisions. It's a lot of discretion to hand to somebody who really, this is like an extra 10% of their already full career. So, reach out to them if you can, if you get the veterans permission. And sometimes, they'll write a statement saying like, yeah, if I did it again, I'd probably give her a second chance. So always a good thing to keep in mind. I have on this particular slide tips for family statements, but it really goes for all kinds of statements. Think about not just positive attributes, but negative, especially when you're dealing with mental health. Sometimes you can have somebody say, when he left for the service, this is how he was. And when he came back, this is who he was. And it really shows some of the heart-wrenching aspects of what the person went through, and that can help corroborate the story of this triggering event that may lead to the misconduct. Okay, personal statement, so important. I can't really go into a whole lot of detail, but please remember to not just start with when they entered service or, when the misconduct started. In the vast majority of cases, it's better to give a whole picture, the whole story arc. As I said, this is a really flexible, creative area of the law, and you want to present this to the board as, this is a person, and this is what happened to them. So I often start with, their family history. Not a ton, but some of the exciting tidbits, like let's say they came from a military family. I talk about why they joined the service, and then start with the military. And then if there's good things that happen afterwards, or sometimes bad things because they're still struggling, I put that in as well. And this is mostly pre-COVID. I often have them notarize it if they can, especially if they're not going to go to a personal appearance. But I mean, not worth it. They can sign it and send it in. Okay, so I could, again, talk about this for a very long time, but I just wanted to give everybody a taste of how you could find contentions, and specifically those improprieties or those errors. And the reason I wanted to touch on this is because I think this is the main area that freaks people out, because they get this military regulation like the MCO that you see, and they're just like, I don't know what this is, and how in the world am I supposed to know if something that happened in the military was an error, because I'm a civilian and I don't know. And I'm not saying that disparagingly. I am a civilian and I often don't know. But what I do know is that when you go to these regulations, just like the DOD memos, which weren't written for us, are our friends because they help, lay out the standard that the board is going to use. These military regulations lay out the standards that the military has to use to separate someone. So, for example, because Sam is a Marine, I have put up, again, quite tiny, an appendix from the MCO, which is a regulation, the 1900.6, which is the regulation that he would have been separated under. So it actually lays out steps that the military commander needed to go through. So just use it as a checklist and go through and see if you have documentation of all of this. And it's incredibly helpful to kind of orient yourself and figure out if things were kosher and everything went okay. And you might be thinking, well, how in the world would I even know where to go to find this? Again, look at that D214 one-page document, but it contains so much. The narrative reason will clue you in onto, okay, pattern of misconduct or misconduct, drug abuse, whatever it is, then you're going to want to go to that in the regulation and see if all of those elements were met. Darren said it's a little bit like criminal law. Like criminal law, there are elements that have to be met. If they're not met, then you may have a good propriety argument. So use it as your friend. And I say, look in the DODI as well. That's the Department of Defense instruction. We love acronyms here. That also has a separation instruction, and all of the military branches have to also follow the DODI. So check that as well. Okay, so going back to Sam, look at this, and I know you don't have his DD-214, but think about, just from the facts you have, what you would pick out when you're trying to, say, go through a regulation or that DODI and find out if there was an error. I'll give a couple seconds. Okay. I'm going to assume everybody has highlighted these parts, because these are the two things that you really should clue in on. Pattern of misconduct, there are actual sections, as I said, where you can go into both the Marine regulation and also the DODI and make sure that those elements were met. And the paragraph actually tells you where to go. So super helpful. That's the paragraph that they separated him under. That was the authority. So if you look at this example, this is actually not straight from the Marines, it's from the DODI, but it talks about some of the elements that you have to have for a pattern of misconduct. And Darren actually brought up counselings. Again, those are not like going to therapy, it's counseling saying you did something wrong. So there has to be counseling and rehabilitation, which means, you have a counseling says you did something wrong, and then you have to give that service member a chance to correct it before you just automatically kick them out. And in this case, the counseling actually has to be documented. So it couldn't just be an oral counseling. You should see that form in the official military personnel file in the OPF when you're reviewing it. And here I just have some common errors that happen in counselings. So again, like failure to even provide a written counseling, failure to have some of the specific details. For example, if a really general counseling and it doesn't tell the service member what exactly he or she did wrong, so they don't know what to correct. Thinking through things like that, which again you can find in the regulations, will really help you identify some clear errors that you can then point to. And just to stick with Sam, here is a page 11, which is the formal counseling form that is used in the Marines. And I know it's small, but this is annotated to kind of show some of the more important parts of that counseling and where you would look to see if everything was done correctly. Okay. So step 4, and this is more if you're dealing with a mental health related claim, although certainly similar things apply if you're dealing with a, let's say, claim that's based on racism or based on somebody being kicked out because of LGBTQ discrimination. But focusing in on the mental health related, because we have Sam, look through the OMPF. A lot of times you're not going to have things that pull out and say, okay, this is a diagnosis and this is what happened. Because if you have that clear connection, hopefully the commander would say, oh, well, he went UA because he has PTSD. Hopefully that would then mitigate the misconduct. So you're probably not going to find that. What you might find are things that may be symptoms of PTSD, not for us to decide because we're attorneys, but it's helpful to go into the OMPF with some of the PTSD symptoms in mind. And that's true with any sort of medical or any sort of mental health issue. I'm just pulling up PTSD because we're dealing with Sam. So look at the DSM-5, your clinics probably have it. Look at some of the symptoms and then, see if some of the behaviors maybe fall under the symptoms. Okay, and then step 5 is the supporting brief. And I could talk again a lot about the supporting brief, but some of the most important things to remember are you are writing this for the board, which is not a board of attorneys. It's not a judge. It's a bunch for the DRBs, they are service members, and for the BCMRs, they're civilians, but they have a lot of knowledge of the military. So that being said, you should not use legalese, although you really shouldn't anyway, because nobody likes that. But you should make very clear, succinct contentions. And contentions is just DU speak for your legal arguments. So up front, I always give a list of the different arguments that I would make. And here you have an example of some PTSD-based contentions. And then I state what I want, the remedies up front again, because I want them to know exactly what we're asking for. And then I go into the really compelling statement of facts where I'm telling the veteran story and go into the argument. Now, one thing to remember is, and I've been on a lot of, or I've listened to a lot of panels where members of the board speak, and sometimes they say, we really just want 2 pages. Like, just tell us in 2 pages what you want. That's nice, and that may be helpful for them, but it's their job to look through all of the documents you send. Don't send voluminous things that aren't relevant, but also don't curtail any of your arguments. And one, that's just good lawyering, whether you're writing to a lawyer or not. You want to make sure that you state all of your arguments and then back them up. But also, when you take these cases, and if you lose, you can then appeal them in federal court. And if you have not made all the arguments because you were only writing 2 pages, because that's what somebody on the board said he or she wanted, then you may have waived some of your arguments and you're not going to be able to bring them back up. So really good idea to spell everything out. And just hammering it in one more time, please make a contention list. I make it at the front, as I said, and then in my argument section, those are my headers. And the reason I do that, the reason I try to make it as clear as possible, because we have, and this is CVLC and the Veterans Clinic at Harvard Law Center did a huge FOIA to try to get some insight into what the boards were doing. And we got back some templates on what they use when they consider cases. So I've shown a snippet of one, and there are a couple others in your materials. And one thing that we found is that all of the boards have, so they have their voting members, but then they also have something called an examiner. And that examiner will look through the application that you send, write up a summary, and then put that in front of the board members along with your whole application. So my hope is that every board member reads everything, but at the very least, you want that summary to very clearly summarize what you're asking for. So be really clear with the remedies that you're seeking, but also state up front those contentions. And a lot of times the examiner will just cut and paste your contentions. And if that happens because you've been super clear with them, then you're framing the argument. If the examiner isn't really sure, then you might lose some arguments and it's not going to be as strong as you would have argued it. Okay, so putting it all together, you're going to have a cover letter. You're going to, of course, have the 293 or 149. You're going to have your really detailed brief with that list of contentions. And then we try to put in a lot of exhibits. Definitely the personal statement is crucial. We give them the relevant documents. Proof of mental health diagnosis is incredibly important if you're making a PTSD, MST, any type of mental health claim. Ideally, you can also get an expert statement that links the misconduct to the diagnosis, even if it's something just saying it's consistent with. A direct link is great, but having somebody say like, yes, going AWOL is entirely consistent with somebody who just suffered from a sexual assault. That's very helpful. And then any other evidence as appropriate, throw it in there, put a nice little bow on it and ship it off. And then wait a couple years, usually. It's not a quick process. Nothing that you've learned today is probably quick. And with that, I'm going to turn it back to Darren.
Great. Thanks, Margaret. So what I'm going to do is speak about how the character of discharge process compared to the DU process can get you to the same result, right? In both cases, we're looking to bring a veteran into VA healthcare, get them access to benefits, and what that looks like. So remember, the DOD is in charge of getting them out and making them civilians, and the VA's job is looking at what a veteran is and whether they're eligible for benefits. So a lot of time I spend time in my clinic, we talk about what actually is a veteran, and the VA defines that for you. And the COD process is getting the VA to accept that the veteran you're working with is a veteran for the purposes, right? And this is in both the code and the CFR, all cited below, right? It needs to be federal service, it needs to be active. Depending on when they served, after 1980, there's a 2-year requirement. And the key here is discharge under conditions other than dishonorable. And that's really the crux of what you're dealing with in a character of discharge case. Like I said earlier, they can start a lot of different ways, but at some point, the veteran, if they're getting their mail, which is a problem we can spend a lot of time talking about, will get the notice, right? You'll have a chance in this VA process to submit evidence and give arguments, right? The central question, right, is whether the veteran is discharged under conditions. So unlike the discharge upgrade process where you're asking the DOD to rethink how this person was released, The COD is focused on whether or not the service provided by this veteran was not dishonorable. You have a right to a hearing at a local level. It can be expedited if the veteran is homeless or facing homelessness. And if denied, which unfortunately does happen, you can go through the VA appeal process as you would any other VA benefit case. Where it gets tricky is that both Congress put forth statutory bars that say if you meet one of these, you are not eligible for VA benefits. And I think some of these are not very surprising. I'm not going to read them to you, but desertion for one, right? Other kinds of very severe incidents. The VA, right, was also given the ability to do some regulatory ones. And we'll come back to this in a second, where they confuse these, and I'll come back to these when looking at them, right? Then there are regulatory bars. So these are bars that the VA have explained in their regulations as they're trying to interpret the statutes to what is not honorable. So not accepting a discharge to escape a general court-martial, right? Sometimes you'll see in the narrative in lieu of court-martial, but there are different levels of court-martial. General court-martial is the most severe. So if it's administrative or one of the other types, that doesn't apply, right? You're spying, the agency law favorite term, moral turpitude. You'll see it in immigration. You see it here in the VA. Homosexual acts involving aggravated circumstances. This is changing. It has changed to a degree. And willful and persistent is the one that we'll talk about a little bit. And at the end of the slides, I'm not going to go through it all. I have some examples of how to break these down so you can look at them. But as I said previously, the VA often gets these wrong. So if we go to willful and persistent misconduct, right, there's an and. You need to be able to do both. The VA will look at, say, oh, well, one's met, therefore it is. Or they'll look at DD 214 where it says pattern of misconduct. Say, oh, if there was a pattern, it must be willful and persistent. That is not what the case law says. That is not what is supposed to happen. But as Margaret said earlier, the people reviewing these applications are not lawyers, right? They have a little checklist that they go through, and 9 times out of 10, they see pattern of misconduct, must be willful and persistent, and will deny them access, even though they are not supposed to do that. And that's not what it says. So let's go back to Sam, right? So is Sam a veteran, right? I think that's the first question we need to ask when looking at these cases. So take a second and think about, is he a veteran? So based on the definition, right, this veteran served 3 or 4 years, right? So we didn't finish the full contract, but finished 3 years. The first 2 years, right, were without incident. That means there were no problems for it being dishonorable. And it was in the 3rd year was a victim of sexual assault. Now there's a good chance that they did not know about that when discharged, or a number of reasons we can get into, right? But either way. So with this, they're going to see this pattern of misconduct, and 9 times out of 10, they're going to say, therefore, it must be willful and persistent. And part of what you would need to do in a case like this is to argue and clarify the law on this. And like Margaret said earlier, and definitely when doing VA cases, you are not going to see a lawyer, maybe at the BVA level, but until the CVAC level. So it's really important that you use plain language, you spell things out, and you explain to them that this is what's going on, and this is the reason of what's happening. Okay. There is a special defense to all of these pieces, right? And that is whether or not insanity is at issue. So a lot of us think about the idea of criminal insanity. This is not the definition, right? You are not barred if insane at the time of the offense, right? So one of those definitions, right, is prolonged deviation from normal behavior, right? So that can mean just not being yourself. And that is very different than raising the level of criminal insanity or being incompetent, right? And there's a lot of case law that goes back and forth if you don't have time to get into in this short period of time where you can spell into that. But there's one case that is really important that I have mentioned here below, which says that it does not need to show causation. So just because you are not yourself at the time, it does not need to be the cause of why you were discharged. Okay, so that was a pretty quick piece here, but I just want to go over this slide one more time because I kind of went through it quickly, and then we're going to talk about a case example, right? These are, to me, three of the biggest mistakes that I've seen and others have seen, practitioners, when dealing with a COD. A conditional discharge, and this is in the slides we're not going to go into, just deals with a veteran who serves more than one term of service. Oftentimes, if you serve 12 years, they don't issue a DD-214 after each contract expires. So oftentimes you'll get one DD-214 that says you served for 12 years, but there could be 11 years of good service. I had one case where a veteran served 18 years, was a drill sergeant, had a mental health break in year 18 and was discharged dishonorably for that last period. And they said, oh, no, none of his service counts. Through a COD, they fixed that for the other terms, and we're still arguing about the last. Willful and persistent comes down to that question of laying pattern to this, and there's both a mental and a physical element to this, the willful and persistent, and they mess this up all the time. In lieu of court-martial, this is super important also for getting veterans access to things like shelter space and other places. Some of the programs that if you have a general court-martial, you are not allowed to access almost any VA services. But there are other types of court-martials which the DD-214 doesn't necessarily get into and are misread it wrong by the VA, where they'll prevent veterans from even getting basic care because they're not reading the form properly. I'm going to stop sharing for a second because I think what we would like to do is kind of take you through a DD-214 that we redacted and see if we can sort of figure out what you would do with this case, right? So I'm going to put that up on the screen. I'm going to try to not do it full screen so I can keep an eye on the chat at the same time. Yeah, and I think, unfortunately, I was trying to keep the chat up when I was in full screen. That was probably the blue box blocking the slides. So I apologize for that. So let me see if I can do this correctly this time. Third time's the charm, right? Third time's the charm. And here we go. Yep, okay. So here is our DD-214 for J. Doe. I'm going to make it as big as I can without bleeding it off the screen.
It's also in everyone's materials, if that's easier for them to pull up.
So here it is. We have a DD-214, and take a minute. I'm going to actually stop talking during that minute and see if you can figure out what you think you would do with this case. I switch screens. Just trying to get it all on here, sorry. This is what matters at the bottom.
So hopefully people can see it and have started to pull out some areas that would be helpful. Darren Darren should have said spoiler alert when he said it's the bottom that matters, because the bottom is a huge part of it. So for DUs, you probably, well, you might be able to see the Army regulation there, but if you look at the very bottom, that section, you'll see separation authority. That's where you're going to want to go and find those regulations. And another thing that you can think about when you're trying to make those arguments when you're in DU land is, you know, I mentioned the equity argument where if something has changed. So you really should get that Army regulation from the, like what it is now, and then also when the veteran was discharged, so that you can compare the two. But that is a block that's hugely important for the DUs. Darren, jump in. I don't want to.
Yeah, no. And if you're doing a COD, it is a completely different analysis, right? So you first need to ask yourself, what is the character of service? In this case, it's an OTH. It's a sign that you're in the gray area that probably needs some clarification, right? So you see the in lieu of trial by court martial. What it doesn't tell us is what kind of court martial it was. So that's one of the things you're going to need to clarify, right? So you're going to be looking at a lot of the same records, right? In the short answer, right, if Margaret and I were both looking at this case, we would probably say, whether should we do a COD or do a DU? And we would say do both. The determination on the end is what the question for relief is. And sometimes Margaret and I have had cases where my COD will be granted before the DU does, and sometimes it's the other way around, right? Obviously, if a DU is granted, the COD becomes moot, right? Because the DOD determination, the VA is bound by it. And to the opposite position, just because you can get a COD to get the veteran access to benefits and healthcare and even compensation, it does not bind the DOD to that interpretation. And oftentimes you're making multiple arguments in a COD as well, right? Even though it clearly says in lieu of court martial, that doesn't mean there might not have been, there probably was other misconduct, which you also need to look at. And some of the same skills you would use that were mentioned earlier when dealing with mental health, looking for markers, the VA is supposed to be doing the same thing when doing COD considerations. Even though they use that language a lot in MST cases, but it should be something that you should be thinking about all the way through. I think one of the differences for a COD for me, and Margaret, correct me if I'm wrong, compared to a DU, is that where the veteran is now is less important for a COD than it is for a DU sometimes. Because in some ways, someone still being homeless, still suffering, actually increases the need for the COD, where that necessarily doesn't persuade the DOD to make changes. What are your thoughts on that, Margaret?
Yeah, that's true. I mean, I certainly have seen cases where the veteran was, you know, still homeless, still an alcoholic, still really struggling. And in part because we were making a mental health based claim that worked and we still were able to get the upgrade. But if you can show something really positive or even like a start to a positive trajectory, that can be really helpful. I would say, especially if you're doing residency case, which I know we didn't get into, but having some positive post-service attributes or things that you can point to is really helpful. You know, another thing that I would point out that is not actually in the bottom, but for DUs is really helpful, and for CODs they're going to look at it as well. And it's really hard to read on this one, so you might want to look in your packet. But when you go up to, Darren, if you can point out where you see the time period that they served, you know, in Sam's hypothetical, you heard that he almost finished a 4-year term. For discharge upgrades, that's really helpful. It's very hard and not impossible. Nothing's impossible in DU land, although it can be very close. It's very hard if somebody, say, only served a year. It's a much easier lift, although no lifts are easy, to say, you know, she almost served 4 years, and then you have a lot of service time to hopefully point to something good. And same with CODs, right, Darren? Because, go ahead. You can.
Yeah, no, definitely, right? Because the question is whether or not their service was not dishonorable. So if they go through a 3.5 years of a 4-year contract and there's one problem at the end, even maybe a one-time drug use, that should not make them dishonorable for VA purposes, right? That doesn't mean that you might not have to litigate it or go through a couple of rounds with the VA, but it's the same idea that the length of time, and depending on when they served, right, contracts were not always the same length. So that's something else that's important to keep in mind as well. One of our considerations is if we do the DU, if we do the COD, because our organization's focuses on access to healthcare, is it going to address that? Any veteran that I'm working with that served prior to 1980, it's a very different analysis, because even if they only served 1 year, right, they would still be eligible otherwise for VA benefits. So I will use those arguments when looking at the character of discharge and not having being bound to, well, they didn't finish their whole contract, because anyone else similarly situated would have been getting benefits at this point.
Another thing I would point out, which you can't really read, but usually from the DD 214, you can see if somebody deployed. There is a foreign service little block within that record of service time. And then when you go to the remarks, it'll also usually say that they were deployed. Sometimes the DD 214s have errors and they don't include information like that, but usually that will be on there. And so when you're looking at a DD 214 before your interview, whether it's for a COD or a DU or both, pulling out some of that information so that you have the background of, you know, what this person's service overall encompassed can really kind of help you come up with some questions ahead of time, and steer the conversation if you need to. So that's another area that we always look at. In this one, I also would look at the fact that the narrative reason for separation is in lieu of trial by court-martial. For discharge upgrades, that makes it a lot harder because the boards tend to look at that like almost like a plea bargain, like they were going to face a court-martial, and so they did this to get out of that. It's unfortunate because a lot of times the commander also could have just given, you know, serious misconduct or something else, and it wouldn't have that same effect. And in many times, especially in the Army, I would say, getting a Chapter 10 in lieu of court-martial doesn't mean they actually were going to court-martial the person. So it's unfortunate that it has, you know, this kind of higher burden. And Darren, I'll let you talk about the higher burden there at the COD level.
Yeah, I mean, I would, unless it's a general court-martial, it's actually, I don't think it's a higher burden necessarily with the COD. I mean, the problem will be that they don't understand the difference. And I don't think you should assume that because someone is reviewing benefit cases at the VA that they're necessarily a veteran. They do have a hiring preference, but oftentimes they're not, right? So assuming that someone who's reviewing the file, the OMPF or something else, do what's going on. Even if the DD 214 is wrong or doesn't have the pieces there that you need, just like for PTSD claim that was mentioned earlier, you can supplement the record by getting it in. Because sometimes certain veterans MOS, they don't necessarily show all of their movements. We had a question we'll come back to about the benefit the VA is supposed to give to the normalcy of record keeping, but they're losing that argument more and more, especially when it at least comes to their mail. They've already lost that presumption. So it is interesting to be thinking about that sometimes you need to supplement, and also about where you get records, because the VA has a duty to assist, but sometimes they still need to be directed. The other big thing about CODs is that it's very possible that the veteran has already had a COD but doesn't know it. Unlike VA benefit decisions where they give you a whole packet at the denial, they'll sometimes just leave the COD determination as a one-page piece in a C file. And unless you go and look for it, you don't know what's going on. So when you talk about under the current regulations, new and relevant material, that's something else that could actually possibly factor in. We've had a lot of cases where even if someone is dishonorable for VA services, the VA should still process the benefits application and give them healthcare access if something is found to be a service-connected disability. So I think that's there. I know we're getting close to the end. I know there were a couple of questions that I think we might want to take before we wrap up.
Can I say one more thing? Two more things before we get to the questions, I'm sorry. One caveat to, we usually do both CODs and DUs at the same time. Sometimes you have somebody who doesn't have a mental health diagnosis, but you think they probably do have that, and you can't get that diagnosis because the person's in a catch-22 and doesn't have healthcare, but also can't get the diagnosis. Sometimes we will wait on the COD a little bit and then do the DU. It really just depends on the situation. That, and then the other thing that I would just flag for people is that finally the regulatory bars that Darren talked about, finally they are being reviewed. So there's a petition for rulemaking out. I believe the deadline is September 8th for comments. So coming up, but it's the first time I think since 1940, I want to say that they've looked at these. So a big opportunity to maybe change those and make them more veteran friendly if people want to look at doing a comment. Okay, I'll be quiet.
Got one of the slides that I totally blew past when I went through there.
That's okay.
The slides will be available on the website, which is great, and they're really going to be helpful, I know, to our students here at Mizzou. There were just a couple unanswered questions. Margaret, is there any great way to get records quickly, an OMPF quickly?
So I wouldn't say great way. So one way is if they're in the VA system, then oftentimes it is within the C file. So if you have VPMS access, it might be in there. I would still absolutely say to do the SF-180 because sometimes all the records don't make it in. Same with if a veteran comes in with the entire OMPF, I still send off for it because sometimes things get lost or they're not put in. The other thing is, and I don't remember the date, but if it's a fairly recent service member, they can often get it online. So that can be, super fast.
Right.
These days, if you have to use the SF-180, who knows how long it's going to take because they're only doing emergencies.
Is being homeless an emergency?
It is, but I don't know what that means as far as the turnaround. I'm not sure what that means as far as the COVID turnaround.
It's relative home, like it's relatively faster. We've also done congressional pushes as well. So if you have relationships with your local congressional reps, they can put a lot of pressure on getting records faster depending on the need. And oftentimes they're happy to do that. That's also relative, right? Nothing is fast in any of these cases.
Right.
Many of you are going to find out, and some of us know way too well, but yeah.
And then we'll end with one more question that was early on in your presentation, Margaret, about presentations to the DRBs in person. You mentioned that you don't get to have many hearings with the Board of Corrections and Military Records, but when it comes to DRB, describe for us how that hearing goes and how you prepare.
Sure. So it is a group of non-attorneys, largely. You can supplement the record up until the day of. So that's important to remember if you are coming up upon the 15-year deadline and you haven't gotten some of those records that you know are important, or you're still waiting for a doctor statement or whatever it is, you can go ahead and send in the 293, ask for a personal appearance, and then supplement it. So that's the first thing to remember. When you go in person, which who knows when that's going to happen again, you sit in a waiting room, and there's usually one person from the board who comes out and talks to you and, you know, make sure that the record is complete and looks through everything with you. And then you're kind of ushered in, and usually they've set up a lot more than I think they should in a day, but I think that's usually because a lot of veterans go in there on their own and they don't have, you know, the full arguments. Sometimes when you go in, they'll say, you know, this is not a trial. We don't want a big opening and closing. It really kind of depends on the makeup of the board. I would always have a very short, succinct one prepared, particularly, you know, stating the remedies and the contentions that you're making. The veteran, will often be asked a lot of questions, which can be very hard and traumatic depending on the facts. Usually the veteran is put under oath. You can technically not do that and just have the veteran, you know, give a narrative, but I've never done that. I don't think that's a great idea. You can get telephonic witnesses. So for instance, if you want to have a, you know, a clinician call in, then that's really helpful because the board often has a lot of questions for that person. So a lot of opportunities now, they are doing telephonic and they're doing video. I'm not sure if all of the boards are doing video now. And actually, as part of our FOIA, we got a template for at least one of the boards on, you know, the process for the hearing. So I'd be happy to send that around too.
Yes, thank you so
Sure.
much. I don't have the words to tell the students how fortunate we all are to have the quality of the speakers that we had today. I mean, this is right in there with the national conferences that I've been to. The quality of the presentations have been amazing, and we thank everybody for their time. And I just have a few closing words. As Judge Bartley said this morning, this is legal heaven. The ability to help people who stood up and stood ready to serve our nation is just really a special opportunity. And for students, I think we heard from some of those on the panel, it really helps you get a job, and it helps you learn how to be a lawyer, and it makes you a really good person. So I hope that for all of the students that listen today, you're inspired and you're ready to go, and I'm sure you're feeling overwhelmed. If you're not, I'd be shocked, but just know that all of these people that you heard from today, we stand ready, willing, and able to help you. We want you to succeed. We want the veteran to have a good experience with the student advocate. So I've got to do a special shout out to the people who made all this happen. The National Law School Veterans Clinic Consortium, which apparently is still named the National Law School Veterans Clinic Consortium, is governed by a board, and the board members made this happen. Elena Duterte, who's the past president, has had a very steady hand for many years, and that continued through today. Matt Wilcott did all the tech stuff, which is a huge job, and we literally could not have done it without him jumping in and doing that. Chantel brought us an amazing speaker in her husband, and also made everybody do what they're supposed to do and coordinated with the court. Christine Husky at Arizona provided a lot of guiding advice. And finally, Hillary Wandler, the moderator, it was her brainchild, and she delivered on it, and I am just feeling very, very fortunate to know everybody and to be able to work with them. So have a great weekend, have a great semester. Reach out if you need anything, we're here to help. Thank you all.